Okay, so this is 580-203. So a tribunal of New York, so a tribunal of this state may serve as an initiating tribunal to do one thing: to forward proceedings to a tribunal of another state, period. But when New York serves as a responding tribunal, it can serve as a responding tribunal for proceedings initiated in another state or a foreign country. 80-204. Here's a way I figured out how I'm actually going to memorize this. So basically what it says here is that New York can exercise jurisdiction to establish a support order. So right now we're only talking about there is no order and New York gets a pleading filed in New York. So how do we know when New York is allowed to establish a support order? So there is no order. Someone needs an order. How do we know if New York can establish it when there's pleadings filed in multiple states? And the ways are, you need three things. The pleading in New York has to be filed prior to the time expiring to answer the other pleading in the other state. That's one. Two is the party that's contesting the other state's jurisdiction timely challenges the exercise of jurisdiction in the other state or foreign country. And the third thing is that if relevant, this state is the home state of the child. So it's like three things, but it's kind of like 2.5. So then subdivision B of 580-204 pretty much simply says the opposite of subdivision A. So again, now this subdivision B is talking about when can New York not exercise jurisdiction to establish a support order. And it says, a tribunal of this state may not exercise jurisdiction to establish a support order if petition or comparable pleading is filed before a petition or comparable pleading is filed in another state or a foreign country if 1. Petition or pleading in other state or foreign country is filed before expiration of time to answer in New York. 2. The contesting party timely challenges New York's jurisdiction. And 3. If relevant, the other state or foreign country is the home state of the child. Okay, so now I'm into 205, so 580-205. Continuing exclusive jurisdiction to modify child support order. And subdivision A is talking about a support order that's been issued by New York. And it says, a tribunal of this state that has issued a child support order consistent with the New York law has and shall exercise continuing exclusive jurisdiction to modify such order if the order is the controlling order and 1. At the time of filing of a modification request, this state is the residence of the obligor, the individual obligee, or the child, or 2. Even if this state is not residence of obligor, obligee, or child, parties consent in a record or an open court that New York may continue to exercise jurisdiction to modify its order. B. So let me go back to A. So now again, this is now talking about when New York has already issued an order. So the original order, the order we're talking about, has been issued by family court in New York. Or I guess Supreme Court. But it says in the article, this state's tribunal is family court in New York. So now this is basically going to be the opposite of what I read in subdivision A, because this is subdivision B, and this is when New York issues the support order, but is not going to have continuing exclusive jurisdiction to modify the order. And this says B, a tribunal of this state that has issued a child support order consistent with the law of New York may not exercise continuing exclusive jurisdiction to modify the order if 1. All of the parties who are individuals file consent in a record with family court New York that a tribunal of another state that has jurisdiction over at least one of the parties who is an individual or that is located in the state of residence of the child may modify the order and assume continuing exclusive jurisdiction. Or 2, its order is not the controlling order. So the reason that they keep saying parties who are individuals, or the obligee who is an individual, is because obviously the petitioner can also be an agency or a governmental subdivision or something in this article. So when they say the individual, they're talking about the actual person, like the parent or whatever, and not like DSS. So with that, here we go to a recap of what B says. B says that if New York issues a support order, that doesn't guarantee that they can always modify it, because if the individual parties file a consent in New York family court, that a tribunal of another state has jurisdiction over at least one of the individual parties, or the child lives there, may modify the order and assume continuing exclusive jurisdiction. Or now, if New York's order is not the controlling order, that's all you need. You only need one of these things. And if one of these things are true, New York cannot exercise continuing exclusive jurisdiction. Next is Subdivision C. Subdivision C. This says, if a tribunal of another state modifies a New York order under UIFSA, New York shall recognize the continuing exclusive jurisdiction of the tribunal of the other state. So the key there is that they're modifying the New York order based upon the principles of a substantially similar law or this exact same law. Because probably what happened was, like, the federal government said, listen, states, we're not going to give you money, or we're going to say we're going to take away some money unless you basically pass this exact law. So at this point in time, all of the states in the U.S. have passed the Uniform Interstate Family Support Enforcement Act or whatever. And I'm calling it UIFSA. And that is what that's saying. That if the other state follows UIFSA and it modifies the support order, New York has to recognize that other tribunal and that other state as having continuing exclusive jurisdiction to modify. D. D says, a tribunal of the state that lacks continuing exclusive jurisdiction to modify a support order may serve as an initiating tribunal to request a tribunal of another state to modify a support order issued in that state. So that just means that you can go to the family court in New York and request that New York assist you in filing a petition for forwarding to the state that can modify the order. Subdivision E says, a temporary support order issued ex parte or pending resolution of a jurisdictional conflict does not create continuing exclusive jurisdiction in the issuing tribunal. So basically, because a lot of times New York Family Court has to issue a temporary order of support, whether or not they have any information about anyone, they have to issue a temporary order of support. So if they do that, and then it turns out there's this jurisdictional conflict going on, that does not create continuing exclusive jurisdiction, because it's a temporary order or an ex parte order or an order issued. All right, that's the end of 205. 206. This says continuing exclusive jurisdiction to enforce a child support order. A tribunal of New York has issued an order, okay? Then another state assumes the jurisdiction to modify that order. When can New York request that the other state enforce its order? And this is the answers. The order is the controlling order, so the other state may have jurisdiction to modify it yet, but they actually haven't modified it yet. So then they can request that the other state enforce New York's controlling order. Or a money judgment for arrears of support and interest on the order accrued before a determination that another state has the controlling order. And then it also says in B that a tribunal in New York having continuing jurisdiction over a support order may act as a responding tribunal to enforce an order. So if another state has this going on where they issued an order, but now New York modifies it, but there's arrears from the other state's order, New York will act as the responding tribunal to enforce the order. All right, so 207 looks like a horrendous, horrible read, right? But it's actually really not a bad section to read. This is the part of the statute where it's explaining what the hell is this controlling order? Which one? There's multiple support orders out there. Which one is actually the controlling order? Maybe more than one of them are in effect. And this is how you figure out which is the correct one that's the controlling order. If only one tribunal has issued an order, easy. That's the controlling order. If two or more states have issued the order for the same obligor and the same kid, this is how you figure it out. A tribunal of this state having personal jurisdiction over both the obligor and an individual obligee shall apply the following rules and by order shall determine which order controls and must be recognized. So the court here actually has to issue an order saying which one is the controlling order. So that's when the proceeding is brought in New York. New York's got to figure out which one's the controlling order according to these steps. If only one of the tribunals would have continuing exclusive jurisdiction under this article, the order of that tribunal controls. Simple. 2. If more than one tribunals would have continuing exclusive jurisdiction under this article, the home state of the child's order controls. Or if an order has not been issued by the current home state of the child, the most recently issued order controls. So this is only if more than one of these tribunals would have continuing exclusive jurisdiction, you go to this second step, which is home state of the child. And if the current home state of the child has not issued an order, you go to the most recent order. Now, 3 says, if none of the tribunals that issued all these other orders would have continuing exclusive jurisdiction under UFSA, New York Family Court shall issue a support order, and that controls. So they don't just take one of the other orders and say that's the controlling order. New York has to issue a new order, and that will be the controlling order. And that's only if none of the tribunals would have continuing exclusive jurisdiction under this article, which is UFSA. Okay, so I'm going to skip a little bit because I don't think that you could possibly make a question out of that. It just says that you can ask for more money and you can ask the court to enforce it at the same time. When a tribunal in New York issues an order which says one of these other orders is the controlling order, or issues a new order, the order has to state 3 things. There's a list of what else it has to state. The basis upon which the tribunal made its determination. So the basis. 2, the amount of prospective support, if any. And 3, the total amount of consolidated arrears and accrued interest, if any, under all the articles after payments have been credited. Now, here we go for a time rule. Within 30 days after issuance of an order, which is the controlling order, the party obtaining the order shall file a certified copy of the order in each tribunal that issued or registered an earlier order of child support. The failure to file does not affect the validity of the order. But if they don't do it, they could be subject to sanctions. And that's whether it's an individual or a support enforcement agency.